Uniform Trade Secrets Act is more or less enacted in about 45 states, okay? And it's not enacted here in Massachusetts. There is a trade secret statute, but it's literally about this long, and it just says what a trade secret is. And it says that, you know, you can go to Suffolk County Superior Court to get an enforcement action. But that's all it says. The Uniform Trade Secrets Act is a little bit more complicated in that respect. And it lays out sort of the steps you need to take and defines a trade secret in some depth. Talks about, you know, injunctive relief, et cetera, et cetera, et cetera. So what some of the legislators did, who are sort of were pushing initially the complete ban, they said, well, how about if we have the complete ban, but at the same time, we'll give you the Uniform Trade Secrets Act. So that's what this Senate bill says, which is out there today. It's number 169. And basically, if you look at page 4, I just want to go through this and point out a couple of things on this particular formulation. Page 4, line 42, it says, no injunction shall issue with respect to a trade secret unless the trade secret is specified with sufficient particularity so as to enable reasonably under the circumstances the respondent, that's the defendant, to prepare a reasonable defense. Now, I went and looked at the Uniform Trade Secrets Act, the way it's written, okay? That language is not in there. Okay? And I can tell you the reason why that language is not in there is, what this is basically saying is that you as the trade secret owner have to disclose your trade secret in full to the other side so that they can say, we don't have your trade secret. So that seems anathema to the entire reason why you have a trade secret, okay? When I draft things that involve trade secrets, I'm either asking the court to impound it so that no one else can see it except the judge, all right? Or I'm referencing it in such a way that you cannot possibly tell, you know, what the secret is per se. All right? What this is saying is that as the plaintiff, you're going to have to go to court with sufficient detail so that the other side can deny what you're accusing them of. But the other side's going to see it. And again, they may not have all the information. In fact, they may have 4 of the 5 elements they need to actually copy your trade secret, okay? And guess what? This is going to make them have number 5, right? The problem with that is even if you win, all right, there's no guarantee that, you know, that someone's not going to take off with that and do something else with it and bury it in some other product. So anyway, this, again, we looked at this and we said, well, yeah, Uniform Trade Secrets Act, good in 45 states, we don't have it in Mass, but you're not really giving us what the Uniform Trade Secrets Act says. You're creating a barrier that doesn't exist, and a disincentive, frankly, for enforcement that does not exist in the actual Uniform Trade Secrets Act. Now, the other issue is, if you look at, quickly, page 6, it's actually sort of the other side of the same point. At line 75, it says, in an action under this chapter, averments, that means like allegations, of trade secrets and misappropriation thereof shall be stated with particularity. Now, that's a legal term, okay? That's a legal concept. The only other mandate that I'm aware of that talks like that when it comes to burden of proof is when you're alleging fraud, okay? If you're alleging fraud in a case, you can't just say, they defrauded me, they should, you know, have to pay me and or go to prison or something like that. You have to be very specific, okay? On this date, Joe Schmo got my credit card number. He took my credit card number to Macy's. He bought this, 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 and this. He pretended he was me. He did this and that. You can't just say, you know, he defrauded me, okay? Well, what this is saying is, again, along with that other language I just read to you, you have to be very specific. Okay, you have to be very specific in your allegations. In a case where being very specific is going to kill you. So, again, that language is not in the Uniform Trade Secrets Act. Okay? Pretty much everything else that's in here, except for those 2 sentences, is in the Uniform Trade Secrets Act. It's a little different, but not much. Now, the other problem that some of us have with this, I call it the horse trading concept. You know, get rid of the non-competes, Uniform Trade Secrets Act, is that every single state that enforces Uniform Trade Secrets Act, with the exception of maybe 1 or 2, okay, so 43 states that have the Uniform Trade Secrets Act, also enforce non-compete. So it's not like you have to have one but not the other. Okay. So again, this was a legislative construct, an idea of let's do away with the non-competes and we'll throw you this bone of the Uniform Trade Secrets Act. And if you look at Section 11, which is on page 7, that first paragraph there, that's the language that appeared as the Let's Do Away with Trade Secrets bill, or I'm sorry, non-competes 7 years ago. Okay. Any written or oral contract or agreement arising out of employment or independent contractor relationship that prohibits, impairs, restrains, restricts, or places any condition on a person's ability to seek, engage in, or accept any type of employment or independent contractor work for any period of time after an employment or independent contractor relationship is ended, shall be void and unenforceable with respect to that restriction. That was going way back now, almost 9 years. That was the language, basically, that was going to do away with non-competes in Massachusetts. Okay. So this language has stayed the same for 7 years. And as I say, as part of the legislative process, and again, you know, we're talking democracy, it's not perfect. The idea was to offer the Uniform Trade Secrets Act, although with certain provisos and limitations, in exchange for doing away with the non-competes. And I'd say right now that really hasn't caught on so well, okay? Because again, conceptually, it's a little more tilted in one direction than it should be. The other thing I would say is this issue is still on the radar screen of the speaker. You know, he's well aware of how the business people in the community feel about this. I think there is some pressure to make a change. I couldn't tell you off the top of my head how the current administration is going to come down definitively on this. Obviously, what you have on Beacon Hill now is quite different than what you had here in the State House. It's quite different than what you had last year. Charlie Baker is a business guy, business background. Karen Polito, same thing, business background, family business. Their perspective, I think, is going to be quite different than sort of the leveling the playing field perspective. Which, frankly, when that was said to me, I said, okay, fine, you want to do that, then have the employees sign the promissory notes and the mortgages and everything else that the business owner and founder has to sign to get the money to get the thing going. You know, if you want to level the playing field. So I just got these dumb, these blank stares or whatever. Anyway, so I can tell you that it is still kicking around up there. I can tell you that things seem to be going slowly for some reason. I don't know. We're in the second year now of this 2-year session, and I'm sure the bills have been assigned. What happens is the bills will be assigned. In this case, it'll be the Joint Committee on Labor and Workforce Development that I've testified in front of a couple of times on this, and then they'll open it up for public testimony. Okay. Which probably, my guess is that'll happen in March or April. So public testimony can either be in person or you can actually submit a written document that lays out your position. So if you're so inclined, one way or the other, you certainly can write to the chairman. There are 2 chairmen, one from the House, one from the Senate. Your thoughts on this, and you can certainly go and testify in person if you want to. It's usually, I want to say, maybe 7 or 8 people testifying. You don't have that much time. You might have between 5 and 10 minutes. But as I say, you can submit a written submission as well. The other thing I just want to point out to you is this book on employee duty of loyalty. The first chapter kind of lays out what the law has been in Mass for a couple hundred years, and it's still the law today. Okay, it sort of sets parameters on what the law is in this area. And again, it's not like every time you go in to enforce a non-compete agreement, it's a slam dunk. It isn't. I can tell you that, as I said, I've had cases where the judges have changed the agreements because under the circumstances they didn't feel that the company needed as much protection as was written into the agreement. Right? In fact, now, the way we do this procedurally in Massachusetts is it's all pretty much on written papers, affidavits, documents, exhibits. Nobody testifies. When you go in, you get all that lined up, you file it with the court, then you go in, you have your hearing, and I'm up there making my arguments, the other side's up there making their arguments. Well, of course, and this can only happen to me. I had a case a couple of years ago where the judge, and much to his credit, said he had never had one of these cases before. He was new to the bench. He wanted to see the people who were going to testify. Okay? He was not going to be satisfied with affidavits. He wanted to see what they had to say, to judge their credibility, etc. And so we had a trial, basically, which virtually never happens on the injunction level in state court. And we took, and again, this is a real-life example, and I bring it up because it shows that this is a very fluid area, and it's not like, you know, an execution when you try to enforce one of these things, okay? You're not trying to kill somebody. We agreed that instead of trying to enforce our agreement totally, we would simply take basically our top customers and ask that this person stay away from it, okay, for the period in the agreement. And they refused. They said, no, we're going to go for broke here. We don't think this is enforceable. You know, they were advised by someone that was actually had been, I think, a California attorney or something. And they said, no, we're not going to do that. Well, believe me, I'm sure this echoed with the judge, okay? Because, as I say, we went in being very, very reasonable under the circumstances. And so we had our mini trial, and the judge basically gave us everything we were looking for. So, and again, we had just limited it to a small number of our best customers. Okay? And the market was quite big in this area, so it wasn't like we were saying this guy couldn't have a job. Even though under the agreement we had the right to make that argument. We decided we were going to do it. That stuff happens all the time. I've had instances where the client said to me, well, yeah, he's violating the agreement technically, but you know what, he's not in a position to do any harm to me, just leave him alone. I don't want to put him on the road. So, more often than not, that's what's going to happen in these situations. The other thing I want to point out in your précis is the last chapter, actually I think it's chapter 7. What I did was, I went through a whole bunch of equity cases I've had over the years, and I illustrated them for you because they're very important concepts, not only in the non-compete arena, but also in the business arena, generally speaking. And they're not really that well known, quite frankly, because they don't always get utilized that often, but they are very powerful and very effective. And I'll just give you a quick example, which I think I did put in here. You pay somebody a certain amount, month after month, to do a certain job, say as a delivery person or something like that. And then 5 years later, you start to say, hey, wait a minute, I think I overpaid you. You know, well, there's a concept called account stated, okay? Again, it's an equitable concept, not a legal concept. Account stated says, look, I submit my bill to you month after month, year after year, for a certain amount of time, and you pay it without complaining. You can't all of a sudden come back to me and say, hey, well, you know, every year I've been overpaying you for 5 or 10 years. Account stated concept, very, very powerful. And it's also the type of thing when it comes to a jury trial, should you be in that position, where you're gonna have a better chance of winning than if you're just sort of pushing a straight legal thing, I think, because the equitable concepts they were created to sort of do the right thing, okay, to be fair. And there's a quote in that article in the beginning about how equity and law are almost inevitably going to come up with different resolutions to the same problem. And it's the truth. It's the truth. Okay, I'm going to stop there, open it up to questions. Again, the legislative process kind of slow, takes a long time. You're going to start seeing hearings in the next couple of months. Now, I will say that the various formulations, either total restrictions or sort of compromise restrictions, have come out of some of these joint committees approved by the joint committee. But that doesn't mean that it's going to be taken up, right? This is why the Speaker of the House and the Senate President are so powerful in our state. If they don't want to take up the bill, it's not going in. Okay? And of course, the governor does have a line item veto. But again, it can be approved by every committee that there exists up there. If the Senate President and the Speaker don't want to put it to a vote, it's not going anywhere. And that's what happened last time with the ban that was proposed. In any event, that's pretty much where we're at right now. Is it going to change? There could be some change around the edges, possibly. I don't know. I really don't know at this point. My guess is no. Okay, I think the air has kind of come out of the tires on this thing. It was pretty hot a few years ago, but like I said, they're still up there, and we certainly weren't expecting, the Senate approval to go through overnight the way it did. And